Hello, my friends. Eric Lee here with Equity Real Estate and Elite Agent Training. And I want to share some fun tales from the convention that we just had. I think it was last week. Time flies. At the Utah Association of Realtors convention. So we had a great legal panel down there. It's my favorite part because it's kind of a really sit up and pay attention type thing. And everybody in the room was like wide-eyed, like, holy cow, these things are crazy. And I want to share some of them with you so that you, in turn, if you're a licensed agent, you sit up and pay attention. And if you're just watching this for fun and you're not a licensed real estate agent, then you'll hire a licensed real estate agent because details matter. All right, here's the story. By the way, this is, I believe, a true story. It's got like real names and stuff, although I'm not going to name the names. So the buyer offered to purchase a motel from the seller. Purchase price was $3.4 million with $30,000 down as earnest money, and the buyer failed to complete the transaction. Okay, so the seller eventually sells it for significantly less money, and then they go back and sue the buyer for damages, saying because you couldn't perform and we had to sell it for so much less money, we took a loss of over $700,000. So the seller is suing the buyer for over $700,000 in damages. Now, here's where the details matter, okay? So Section 16 of the real estate purchase contract states, if the buyer defaults, then the seller may elect one of the following remedies. Number one, they can cancel the purchase contract and retain the earnest money deposit or deposits, if applicable, as liquidated damages. Liquidated damages just means that this is all you get and you move on with your life. Everybody moves on, okay? Or you can, number two, maintain the earnest money deposit or deposits, so you keep that in a trust and sue the buyer to specifically enforce the purchase contract. So we're saying, no, you can't cancel. You have to close on this home. That's a tough one sometimes. If they can't do it, they can't do it. And a judge can't force them to do something that they can't do. So not a lot of people go that route. Potentially could, though. And number three, return the earnest money deposit or deposits, if applicable, to the buyer and pursue any other remedies available at law. Okay, so we can either keep the earnest money as liquidated damages, we can sue for performance, force them to close on the home and buy it, or the motel in this case, or we can give them back the earnest money and pursue any other remedies available at law. Now, in this case, they were suing for $700,000. So they sued for $700,000. And the buyer comes back and they said, hey, they shouldn't be suing for $700,000. They haven't released the earnest money to us. And so the seller, or let's see, no, who's suing who here? Okay, buyer default, so the seller was suing. So the seller had kept the earnest money. Buyer says, hey, you shouldn't be suing us because you kept the earnest money and you haven't given it back. Seller gives back the earnest money and says, now we're suing you for the $700,000. And it went all the way to the Supreme Court. So this was expensive, okay? So we've getting to the Supreme Court, there's a lot of attorney's fees wrapped up in this. And the Supreme Court said that it is a basic principle of contract law that parties are generally free to contract according to their desires in whatever terms they can agree upon. Okay, so you guys have contracted and you've agreed on these terms, and now the language matters. And so you're suing for $700,000, but you didn't give back that earnest money. And the language says in the contract that you return the earnest money and pursue other remedies. And because they didn't return it, they kept it and then pursued. And then when they were challenged, then they returned it and then pursued. The judge says, no, all you get is the $30,000 earnest money. And so they lost potentially $670,000 earnest money because they missed that one detail. There's an and in there that they need to return it and then pursue, rather than pursue and then return it sometime down the line. Okay, so do details matter? Absolutely. Now, if you're a real estate agent hearing this story and you're thinking, I don't know how this applies to me. I don't deal with $3.4 million homes. I'll tell you what, when you dig into that real estate purchase contract, there are a surprising number of ands. All right, when you dig into state law, which is just super fun. I do it every week as a part of my job as principal broker. When you dig into state law, There's some ends that will surprise you. And so making sure those details are known by you is very, very important. This is part of the value that we provide as real estate agents. And this value, in this case, was worth nearly $670,000. So, and thankfully, one of the parties was aware of that, or their attorneys were aware of it, and saved them a lot of money. So real estate agents, are you worth the money? You absolutely are. If you're doing your studying and you're understanding your forms and you're helping advise your clients well, then yes, you're absolutely worth it. So get out there and do a great job today, guys.